Good morning, everyone. So, today we will have some basic knowledge about what is evidence law and what does Indian Evidence Act contains and teaches us. So, without wasting any time, let's start with it. With the first question, that is, secondary evidence is admissible. In what situation? The options are A, where the non-production of primary evidence has not been accounted for. B, where the non-production of a primary evidence has been accounted for. C, irrespective of whether the non-production of primary evidence has been accounted for or not. D, both A and C are correct. The correct answer to this question is option B, that is, secondary evidence is admissible where the non-production of primary evidence has been accounted for. The next question is, oral account of contents of document is admissible when? The options are A, when given by a person who has seen and read the document. B, when given by a person who has seen but not read the document. C, when given by a person to whom the document was read over. Or D, when given by any of the above. The correct answer to this question is option A, that is, oral account of the contents of the document is admissible when given by a person who has seen and read the document. The next question is, a document required by law to be attested can be proved under section 68 of the Evidence Act only by which of the following options? A, by calling both the attesting witnesses. B, by calling at least one of the attesting witnesses. C, by calling none of the attesting witnesses but by calling some other person who has the acknowledge of the contents. Or D, all of the above are correct. The correct answer to this question is option B, that is, a document required by law to be attested can be proved under section 68 of Evidence Act only by calling at least one of the attesting witnesses. The next question is, the calling of at least one attesting witness to prove a document under section 68 is not necessary in what situations? The options are A, when the document other than a will is registered under the Indian registration. B, when the document including will is registered under the Indian Registration Act 1908. C, when the documents irrespective of whether it is a will is registered under the Indian Registration Act 1908. Or D, both B and C are correct. The correct answer to this question is option A, that the calling of at least one attesting witness to prove documents under section 68 is not necessary when the document other than a will is registered under the Indian Registration Act 1908. The next question is, a will is required to be proved by calling at least one attesting witness. In what situation? The options are A, when it is registered. B, when it is unregistered. C, when it is admitted. Or D, all of the above. The correct answer to this question is option D, that all the above options are correct. That means to say a will required to be proved by calling at least one attesting witness when it is registered, when it is unregistered, or when it is admitted. The next question is, public documents are mentioned in which of the following sections? Options are A, section 72 of Evidence Act. B, section 73 of Evidence Act. C, section 74 of Evidence Act. Or D, section 75 of the Evidence Act. The correct answer to this question is option C, that is, section 74 of the Evidence Act, public documents are mentioned. Section 74 of the Evidence Act states public documents. This section states that the following documents are public documents, that are first, documents forming the acts or records of the acts of a sovereign authority, of the official bodies and tribunals, and of public officers, legislative, judicial and executive, of any of the part of, or of the Commonwealth, or of a foreign country, or of any part of the India, or of the Commonwealth, or of a foreign country. And second, public records kept in any state of the private document. The next question is, documents which are not covered under section 74 of Evidence Act are called what? The options are A, semi-public documents. B, quasi-public documents. C, private documents. Or D, all of the above. The correct answer to this question is option C, that means to say Documents which are not covered under Section 74 of Evidence Act are called private documents. The next question is maxim omnia prostimatur right esse acta means what? The options are A. It means that all acts are presumed to be rightly done. B. It means all acts are presumed to be not rightly done. C. It means all acts are presumed to be wrongly done. Or D. It means all acts are presumed to be not done wrongly. The correct answer to this question is option A. That means to say the maxim omnia prosperinter right esse acta means all acts are presumed to be rightly done. The next question is admissibility of electronic record has been prescribed under which of the following sections? The options are A. Section 65 of the Evidence Act, B. Section 65A of the Evidence Act, C. Section 65B of the Evidence Act, or C. Section 66 of the Evidence Act. This question is option C. That means to say Section 65B of the Evidence Act. The admissibility of electronic record has been prescribed. The next question is principle omnia prosperinter right esse acta is contained in which of the following sections? The options are A. Section 78 of Evidence Act, B. Section 79 of Evidence Act, C. Section 80 of Evidence Act, or D. Section 81 of Evidence Act. The correct answer to this question is option B. That is, Section 79 of the Evidence Act talks about the principle of omnia prosperinter right esse acta. 79 of the Evidence Act states presumption as to the genuineness of the certified copies. This section states that the court shall presume to be genuine every document purporting to be a certificate, certified copy, or other documents which is by law declared to be admissible as evidence of any particular fact and which purports to be duly certified by any officer of the central government or a state government or by any officer in the state of Jammu and Kashmir who is duly authorized thereto by the central government, provided that such document is substantially in form and purports to be executed in a manner directed by law in that behalf. The court shall also presume that any officer by whom any such document purports to be signed or certified held, when he signed it, the official character which he claims in such paper. The next question is Section 79 of the Evidence Act applies to which of the following? The options are A. Certificates issued by government officer, B. Certified copies issued by the government officer, C. Other documents duly certified to be genuine by a government officer, or D. All of the above. Then the correct answer to this question is option D, that all of the above. That means to say Section 79 of the Evidence Act applies to the certificates issued by the government officer, certified copies issued by the government officer, and other documents duly certified to be genuine by a government officer. The next question is Section 79 of the Evidence Act contains what? The options are A. An irrefutable presumption of law, B. A refutable presumption of law, C. A presumption of fact, or D. No presumption either of fact or law. The correct answer to this question is option B, that is Section 79 of the Evidence Act contains a refutable presumption of law. The next question is Section 79 to 85 of the Evidence Act contains what? The options are A. Presumption of facts, B. Irrefutable presumptions of law, C. Irrefutable presumption of law, or D. Irrefutable presumption of fact. The correct answer to this question is option B, that is Section 79 to 85 of Evidence Act contain refutable presumptions of law. The next question is presumption as to the accuracy of maps and plan made by the authority of the government is contained in which of the following sections? The options are A. Section 81 of Evidence Act, B. Section 82 of Evidence Act, C. Section 83 of Evidence Act, or D. Section 84 of Evidence Act. The correct answer to this question is option C. That means to say presumption as to the accuracy of maps and plans made by the authority of the government is contained in Section 83 of the Evidence Act. So let us now see what does Section 83 of the Evidence Act explains and states. Section 83 states presumption as to the maps or plans made by authority of government. This section states that the court shall presume that maps or plans purporting to be made by the authority of the central government or any state government were so made and are accurate, but maps or plans made for the purpose of any cause must be proved to be accurate. This was the end of our first presentation. Hope you all liked it and hope this presentation or video was able to teach you something about the civil procedure code. Thank you for watching it. Thank you.